start. Good evening and welcome to the Belgrade Planning Board meeting of Thursday, December 4th, 2025. And I'd like to call the meeting to order. We have a quorum. Tonight we have Mrs. Penny Morale. We have Mr. Richard Baker. We have Mr. Nick Sakaro. We have Mr. Peter Surgeon. We have Mr. George Seal and Mr. Craig Alexander and myself, Sarah Langet, together with Mr. Hans Rasmussen, CEO. And I would like to invite the audience to introduce themselves.
Yeah. I'm Jeffrey Smith, a butter at 324 Sandy Cove Road.
Thank you.
And I'm Chris Nagel, and I am Jeff's attorney.
Thank you.
David Bean, 308 Sandy Cove Road.
Thank you. And I will invite the audience in the Zoom, that joined by Zoom, to introduce themselves as well. Let's
Good
start.
evening. Oh, sorry.
Let's start with Mrs. Metcalf.
Okay, good evening. My name is Judy Metcalf. I apologize for not being present. The drive up there was just a little too overwhelming with the stiff winds today. I represent the applicants, Jody and Stephen Jones.
And I cannot read the lady that is under the phone.
Steph.
Thank you. So,
That's Jeff's wife.
right. Would you like to say something for the video, Mrs. Stiff? We cannot hear
She
you.
said, no, I'm good.
Oh, okay. Right. So, just know that we didn't hear you now. If you need to speak, you gotta unmute it. That's all. But I guess we read your lips. Okay, sounds good. So then we also, I think, I recognize that picture. That is Mr. Alexander there, Nick Alexander. You wanna say something, Nick?
Hi, I'm Nicholas Alexander, town resident.
Thank you. So nice to have you here tonight. And then the other person that is logging is me, yes, just in case I need to share my computer. All right, other than that, I think we are full.
S is you.
This is me.
Okay.
Yeah. So with that, we have a tremendous amount of information floating around with this application. This is my file, all right? And specifically from last meeting to this one, we were able to obtain videos from the applicant for the both structures, all the interior of both structures. And we also did a site visit. There's a summary of the site visit. Basically, in the site visit, we couldn't get inside the buildings. We just walk around both structures. We, for our own satisfaction, we took measurements there. And everybody in the board, I think with the exception of Mr. Alexander, was able to make that site visit. And each board member with their own eyes saw the site and the structures, right? That said, before going too deep into the evening, as a board, we have to dialogue a little protocolarian aspect. Last time we met for this application, we had a quorum of the board, and we have 5 people here, and Mr. Baker was not present, and neither was Mr. Alexander. And then when we went to a site visit, because we crunched the date in the meeting that Mr. Alexander missed as well. And you know, different than Mr. Baker, Mr. Alexander have a day job, Mr. Baker is retired. More time to dedicate
Man of
to,
leisure.
yeah, have time to dedicate to these things. So Mr. Alexander wasn't able to attend the site visit. Would it be okay with the board to have the first 5 that we were there initially in order to funnel a final decision on this application? How you feel about that, Mr. Alexander?
Well, I mean, I watched the videos.
We didn't vote on that.
We didn't vote,
Application being complete,
but-
it's just preliminary.
sure, but I guess my point is because one board member of the regulars was not present
I
at
guess
both
it's
of
up to
them.
him.
It's up to.
Voting, no.
It won't matter to me, I just wanna make sure that we're all in agreement.
If if Craig's seen the videos
Yeah.
and has reviewed the materials according to the MMA planning board handbook, he should be able to vote.
Yeah, I've seen all of it. The only thing I didn't see is, the interior of the existing camp. For some reason it was blacked out on the email.
But we're gonna watch those tonight.
I was gonna say, I didn't see it either.
Yeah.
Blacked out on-
Yeah, I didn't feel either.
We're
Other
gonna,
than that, I saw what was existing in the camp, little garage, and,
the questions I have of all those videos, so I would like to have each one of you guys look at it and look at them together. So are you okay with that?
I'm fine.
You actually relief, huh?
Very.
So anyways, so that said, we had that covered, we all good with that. And, so we had the video and we had the memo of the site visit. And then usually this board, receive all materials by the Friday before the Thursday meeting. And, this week, even Monday morning, we got some stuff, and we got some stuff as late as yesterday as well. Specifically, the information from yesterday is a thick document, there's 6 pages of information, and then exhibits in it. So it's soaking this overnight is a little bit difficult. So at one point I would entertain the person that originated the document to go over it. I think it would be fair if you guys are okay with that. All right. So let's start. Should we start with the videos? Watching the videos? Go ahead.
Just since you've already started off with mentioning some of the information that's been provided to us since the last meeting, there were a couple of items that weren't mentioned. One is your
Sure.
email of 11/24 that includes the table that Mr. Nagel had requested with the square footages of the different types of uses in both the existing and the proposed structure. So that the record's clear on that. And the in addition to Ms. Metcalf's office providing us the video, the ShareLink video of the existing and proposed structures, the interiors, that also provided was a schematic showing the dimensions of the interior of the existing structure along with dimensions and their what the different uses of the different rooms are.
Yep. Also in the website, we added three documents, I'm glad that you,
There's the Forester's report.
yeah,
There's a site visit from 2019 notes. And what else is there?
There's one more thing.
The,
schedule-
Oh, and the soil erosion control plan for
Thank you.
2019.
Thank you.
So that's all part of the public record at this point, should be part of the project fund.
That's schematic, that's the primary residence.
Correct. The existing structure is the way I
I
like
didn't
to
know
refer to it.
Yeah,
Just for the record and, just not to label one structure, in relation to another, we will talk about two different structures. Structure one was the one that was there first. Structure two is the one that was done after. We're not gonna use any other terms but those two, and I use P in the table to refer that as the one that is in proximity to the lake. That's the first structure. And then A will be the one that is away from the lake, way away from the lake. So it's one closer to the road. So we're gonna keep those two terms going just for the benefit of everybody. So if we're talking about structure one, is the one in proximity to the lake, the first one that was there. Structure two is the one that was built after that, that is away from the lake, closer to the road. I got all that clear?
Yeah, and I got a question.
Okay, go ahead.
On the document dated 2020,
Yeah,
why is that part of this discussion? What?
that was
That's the Forester, back in
I
2020.
would like Mr. Seal explain that.
I had asked at the last meeting that the key documents from the prior review of the same structure be submitted to the record. And the reason is because there's information there that we otherwise would not have. In the case of the forester's report, it speaks to whether or not this meets the clearing standards. With regard to the soil erosion control plan, that's goes without saying with that. And with respect to the site visit, it verifies a number of things, but the lack of stormwater runoff control, and it all as well as which complements what we saw at the site visit we most recently did, but also the distance from the lake, which also is consistent with what Hans found, that it's over 100 feet away. So just so that we have a complete public record with all the information we need to make a solid decision.
Okay, thanks.
All right. So with that, should we proceed to watch the videos? Is that something that you can pull from there? So if you guys would, what I'm gonna do for myself is get the site plans for both structures and get them right to myself here, so I can follow that as I'm following the video. And
You ready?
be marking what we see. You have to do like a little bit at a time. So that's the entry to the away structure, the second structure, right? So we see a sofa there.
Building under.
That's correct. That's a building under the application right now. So
I apologize. Can't continue.
so before we go into this, is something that you would like to share or something of that sort?
Not at this time.
Okay,
I was just asking a question. You mentioned the sketch that came out by email, but I didn't see that in the list of documents on the website.
It wasn't on the website, but it was among other. The number that we received while in the interim, including, all your attorney's memo.
I thought we shared that with the attorney. Is that
You
it?
did, you did. You sent it, I
Okay.
sent it to Jeff when you sent it to me.
Okay. So, are you all set?
I'm all set.
Okay, good. So, that said, do you have an extra copy of that?
Yeah, just add me.
Oh, for me?
I'll do that.
Oh, you have it right here?
Yeah.
No.
It was only made about.
I'm sorry about that. Right here, yeah, I got it. Thank you. So, so that entrance there seems to me like it's like a living room, if we would, or what is called the playroom. Is that correct, Mrs. Metcalf?
I'm sorry, Ms. Langrat, I cannot see what
Or
you're
you cannot see
seeing,
the video?
so I'm watching them separately. So are you looking at the video of the building 1 or building 2?
Building 2, that's the building
Okay.
that is away from, closer to the road.
Yep. So
And
your
the
question,
start of it,
Yes,
I
so-
think we can cite to you probably the seconds where we stop.
yeah,
We are in at the beginning of it. You know,
yep,
just at the
I've got it.
beginning.
I'm looking at it separately because I can't see your share screen.
Sure. You know, I can share my screen. You wanna do that?
This
I-
is not inside of the Zoom, this is
But I am,
private.
and I have,
You do
you
it.
wanna try? It will make the communication easier, just bear with us, Miss Metcalf, and
Oh,
this
no problem.
technology stuff. Let's see if we can make that happen. So the first thing I gotta do is actually, get that. Um, um, almost there.
Pretty self-explanatory when you watch it. I don't know if we have to stop it every 2 seconds.
Okay,
We just played the video. If we have any questions, we can ask.
yeah,
Yeah.
so I got it, I'm right here now. Just patience, it's a virtue. So now. I am in the Zoom. Okay, and I'm gonna share. Um, Now I'm gonna go and share my screen. And. Okay. Share. So now you're seeing my inbox. Like pretty soon. Okay. Right there, should be right there, come on. Why is doing my inbox only and not, I have the video uploaded. Hmm. Let's try to get out of there.
Can you minimize your outlook?
That's the one I'm working on that one.
She's minimizing it, but it's not minimizing it.
So, let's close the window for that, I don't need that. Okay. And now. Screen sharing has stopped. Okay,
Let me see, I'm not good at this, I don't know what I'm doing, I just want to see.
shared. And I
There
wanna,
it is.
oh, okay, there we go. Now,
All right,
now, I
okay,
got it, I
I
got
got
it,
Oh, I'm on it, ready?
now we are.
I'm impressed, Sarah.
Don't cut out yet, hold a second.
Sarah, this is my screen. Yeah.
That's your screen? But she, Mrs. Cap cannot see it, can she?
I can see this, yes, thank you.
Okay, great. So what we see there now is a playroom, a living room,
The playroom, yep,
yeah, is that correct?
that's correct. And what will be taken out is that counter and that sink.
So, but that's not taken out yet.
Right, because we need the permit to be approved to do the work.
Sure, we're in the right structure.
You're in the
Yeah,
correct structure. This is building 2.
The applications.
And in the back is what used to be a kitchen. And
Yeah, I can see, that there seems to be a space for a stove, a space for a microwave on the right, and then on the left, it's a space there too. Was that a space to a laundry room?
Refrigerator.
Oh, refrigerator. Okay. All right. So, good. So we can keep going. So we enter in the actual garage bay. All right. And that's the bathroom. Now, in that first, can you stop, please? Yeah, thank you. So that's the first floor right there.
Right.
And do you think that I'm missing the first floor is seen in the sketch that we have with the application, back of that bathroom? And if you see the garage door to the back, right corner there, there's a door. And in the print that we have a laundry, room, so to speak, isn't it?
There's no laundry facility in there right now, but there would be a laundry hookup there.
Okay, so that presently does not exist now.
I believe the plumbing is in the corner for the laundry hookup. But there's no washer and dryer in there right now. The building's not being used.
The plumbing's there, the washer and dryer hookups there. You got venting, you got, so it exists, rather than machines are there, no, it doesn't matter.
Yeah. I would just remind everybody, we need to look at this as if the structure doesn't exist.
Right.
So whether, there's an outlet there or isn't an outlet there, if there's a washing machine there or isn't there, doesn't matter. What matters is what's in the application.
Proposed.
Yes, what's proposed.
So then we're saying that then there's gonna be a laundry there. Cause it's in the drawing of the application.
If they're funding it, they're asking for it.
Okay. So, let me see here. So. We have a laundry and we have the garage bay. And we didn't saw it in the video, but in front of that structure and the first floor, there's a porch. Is that right?
That's what you saw. Yep, you saw a covered patio area facing the lake.
Okay. That was at the side visit, but it's not in the video. And then, we have a full bathroom and that's first floor.
Well, I would call it a 3/4 bath, but yes, there's no tub, there's a shower.
Okay. Right. So that's first floor there. That's all we have with that. And then we, the kitchen is in the proposed drawing is a whole playroom. And there's gonna be no kitchen.
Right. It said we're removing cabinetry, sink, countertops, and island.
It's good. So, is everybody, happy with the scene so far?
Yeah.
So we can keep moving to the video,
Yeah.
Nick? Okay, so let's go upstairs. That's one bedroom. Bathroom.
Two bedrooms now? Well, I just,
Two-
one bedroom, there's another room there.
That room is proposed to be, is a bedroom existing now, but in the drawing says it's gonna be off, it's gonna be taken off. And that's a second bedroom there.
And which wall's coming down?
The
That
very,
wall right
the second one that you put in between, the second empty, the second space that you saw that is empty.
Yeah.
That's the third bedroom, but that wall's gonna get done, the one, that wall between that space and the bathroom.
This wall right here that you look
Yeah,
at.
yeah.
Okay, so that, wanna make sure that that's clear in the application. That such is, coming down. So, sure, go ahead, please.
Ms. Metcalf, this is George Seal. The question, I just want to reaffirm my understanding from the first meeting when we went over the plans in the application for, the proposed structure, AKA structure number 2, the area that we just saw in the video where the wall's gonna be removed and, at that time, I had written down in my notes, based on a question I asked, that that was going to be converted to a living room from a bedroom. Is that correct?
Right. It'll be a sitting area, living room, what you would do in a loft, in a landing at the top of a staircase.
Yeah, that's right. Just on the other side of the hallway from the
From the back.
staircase.
Yep, that whole wall is coming out.
Right. And okay, so that's going to be a living area, not a
Yes.
bedroom.
No,
Okay, thank you.
Now, is that gonna be added in the print?
I'm sorry, Ms. Lingblad, I did not hear your question.
Is that gonna be specified in the print? Cause that, right now it's not, it says only remove door, entire wall to rebuild in an open area, but it doesn't specify that the open area is gonna be, I mean, we're downloading that, but it does, in the paper, it doesn't say that it's gonna be a living room.
Well, I think that I would direct you to the fact that the application on the front page says there will be only 2 bedrooms. And so the remaining area will be living space, but no bedroom.
Number 6.
I, for my take, I think that open area underneath to say then living room, future living room.
That's labeling it.
Well, if they just keep it as a sitting room, if you're sitting there.
Daily whatever.
Open space, maybe there's nothing.
Okay. So,
Go ahead and sleep it.
So upstairs, we have only 4 rooms, 2 that are gonna be bedrooms, 1 bathroom, and 1 living play space. In the first floor, we have 1 bathroom, one playroom, a laundry room, a porch, and a garage. Are we in agreement with that?
Yes.
Okay,
1 bedroom, it looks like 2 bedroom.
Bedrooms.
2 bedrooms, yeah. Upstairs, we have 2 bedrooms, 1 bathroom, and 1 living space.
Upstairs you have 1, not 2 bedroom, 1. Upstairs.
Upstairs, we have 2 bedrooms.
Is this, building 1 or building 2?
That's building 1. We're talking about building 2, Mrs. Morel. We're talking about this one here, the one for the application.
Yeah.
So let's review this again.
Yeah.
In building 2, we have, in the first floor, we have 1 bathroom, 1 playroom, 1 laundry, 1 porch, and 1 garage bay.
We have more than 1 bathroom. We have,
I'm talking first floor.
oh,
First floor. Second floor, we have 2 bedrooms and 1 bathroom and 1 living space.
for a total of 2 bathrooms.
That's right. Yep. So,
I would just point out for the record that that this is different than the table you had done at the first meeting.
yep,
If you compare the site plan with this, that was presented in the application, and you look at the site sketch, the sketch that was provided of the building number 1, the existing building, they're slightly different than what was in the table that was provided to Mr. Nagel, at his request.
yep. So that was that, like the draft.
Yeah, I've seen that table, thank you.
We going over that, to record it, that we see what we're seeing now. So we have a total of, in the away structure, we have a total of 2 bedrooms, 2 bathrooms, 0 kitchen. We actually have 2 living playroom spaces, okay? Change that to 2, yeah. We have 1 laundry room, 1 porch, and 1 garage. So that original table, at least for the away structure, changes only on the living play. There's 2 of them. Right? So everybody happy with the away structure, the number 2 structure. We're good with that. So we're gonna move on then to the number 1 structure, the one that is in proximity to the lake. You have questions, Mr. Seal?
No,
Okay.
scratching my
Oh,
head.
I thought you were raising your hand. All right. So everybody has their drawings. This is the ones I came through email. Very nice hand sketch drawings here. We have a first floor and then the loft being drawn. So if we can see that video, that'd be great. Can you see that video from your end, Mrs. McCaff?
Yes, I can.
Right, excellent. So
Ready?
there you go. So that's the entry there, and that's seems to be like a together dining room and living room and kitchen in the same area without no walls, no separations. And then we go in the back. Can you pause it there? And so we have so far then in that first floor, we saw a kitchen, a dining room, and a living room. All right. And so now we entering into in that same first floor, we entering in a bedroom. And then we exit and we go in a bathroom. Well, that's a full bathroom actually with that's a laundry. It's a laundry bathroom. And you saw it there for a second hand. So we have a laundry and we have a full bathroom in that first floor. And then we're looking at another bedroom in the first floor. Right, can you pass their hands, please? So far in that first floor, we have 2 bedrooms, 1 bathroom, 1 kitchen, 1 dining room, 1 living room, and the bathroom and laundry are together. All right. So is that correct, Mrs. McCaff?
Well, I think I would just quibble with, I think it's 1 dining room, living room area, which is open to the kitchen. I don't think they're segregated rooms. And the same with the laundry facility. The laundry facility, the stacking washer and dryer is in a bathroom, which has a sink, a toilet, and a shower stall, based on the drawing and the video.
Yeah, they're not separate rooms, but the fact of the matter is that there's a kitchen in the open area.
Yep.
There's a dining room in the open area. There's a living room in the open area.
Yep.
And then even when the bathroom and laundry are together, they're both in that room.
Right, multiple uses.
Yeah, multiple uses. All right. So Mr. Steph, have a question.
In addition, that's not on the sketch there, there's a covered porch and a
A deck.
deck.
Oh, yeah.
In addition.
Yeah. when we went in the site visit, we had that, we saw that. So I'm gonna mark that up, so there's a porch and a deck. In that first floor. All right. So now we're going to the second story of that building, that structure, and the second story it's like a loft, not real, not a full story. So that's a loft right there. Has a bed in the back. Full bathroom. And a bed. So essentially then, in the second floor, we have, three uses. We have a bedroom, bathroom, and a loft that is basically like a living area, isn't it? It's an open space. Is that right, Mr. McCaff?
Yes, that looks that from the sketch and from the video, that's what I understand.
All right, perfect. So then, if you would, updating that, simple chart, we're talking about then, 3 bedrooms from the structure that is in proximity to the lake. And we're talking 2 bathrooms. All right, we're talking 1 kitchen. We're talking, 2 living places, play or living places. We're talking about 1 laundry. We're talking about 1 porch. And 1 deck, and the away structure has 0 deck. And then 0 garage.
And I'm not sure we have 2 comment, the living, dining area is all 1 open space area
Okay,
rather than 2.
well, we're calling the loft on the second floor a living space, living room space or play space.
In
That's
the
why-
existing structure.
In the six, in the one that is in proximity to the lake.
Okay. I wouldn't have done so, but
So what you would call,
They call it a loft.
yeah,
so what's the difference between a loft and a living space or a living room?
from the video, it just looked like vacant, unused space. I mean, it doesn't matter because in the end, it's, what uses are in each structure.
Mr. B,
Wasn't there a bed up there in the loft? You know,
Again.
it looked to me like there was a bed.
did, but what they use that for, is just simply, and we go back to that place too.
Even if there's a bed, it's still locked.
all open.
Yeah, it's all open, bedroom.
There's a sofa, there's books.
Yeah, a little bit up there.
And they kind of sectioned it off, so it's kind of removed from the rest of the loft area. I'm just pointing it out. So,
Yeah, so that was a good observation. I mean, the fact of the matter is, they can do with it whatever they want, because we don't regulate that.
Right.
It's just a matter of point of comparison.
You know, in a living room, in my house, we have a sofa, and the sofa is a sofa bed. So you open it, it's, you know, I don't know, I would call it, I don't, it's just one more space, can be either is not, as it, consider that a bedroom is difficult because it's not closed in. But I would say it's a place where they can sit, they can,
Doesn't closet, I don't know if it has a closet.
yeah, huh?
No egresses.
Yeah, there's no egress, you have to have a closet. But it's kind of irrelevant.
Okay, so anyways, so that said, then we're good with the videos and we good with the I guess what we shut up here, so to speak. The other item that I had is the memo of the site visit. I took time to put those numbers together. And it's something that happens a lot with applications here because applicants are, so to speak, new to this process. Is for the board is something that is secondhand. Measuring and determining what is what, where to measure from and what not, becomes conundrum to many of them. So we had numbers, and instead of footprint, the shoreline zone is geared to understand the area in the lot that is taken away from vegetation, so to speak. So we, in any application we ever had done, we talk about square footage that is taken in the ground by the first floor. Whatever square footage is in the second floor, and we usually in this town will not have a third floor more than a second floor because the limit here is 25 feet, 24 feet height. 25. And the reason for that being is we have a fire department, the fire department have a specific set of equipment. It can go up to 25 feet in the fire, and that's it. So we're regulated, huh?
This was due to the facility to right of ways. So.
And this part of the land zone had to do with aesthetics in terms of limiting the size and not being way up.
That's why some short, proximity to the right of ways and aesthetics. Because it's 30 feet. The lower building. Shoreline. So it's not due to the fire problems. It's due to fires and the roads, and aesthetics.
Well, and as Rich mentioned, it's also what is required by Chapter 1000 in DEP's regulations. So we don't have a choice in the matter. This is the bottom line.
So, but then.
So when we talk about the square footage of a structure, we, as a board, we always have looked at the first floor. We don't know what footprint.
But always the footprint.
Which
Square footage is volume.
includes
The overhang.
the overhang, not just the foundation.
Okay, So that would include the porches and the decks.
Right.
Yeah. All right. So then, the final number for this thing is a square footage for the first structure there, the one that's in proximity to the lake, is 2,016 square footage. And the second structure, the one that is away from the lake, that first floor with a porch is 1,100 square footage. So that said, we're talking about that second structure being 55% of the first one. I have the numbers in a spreadsheet here. These are my numbers. I don't know if you guys want to see it in the
We
screen.
measured it.
So the first structure is a 48 by 42, and multiply those two is 2,016 square footage. And then the second structure, the one that is away from the lake, closer to the road, is 36.7 feet in the length, and in width is 30 feet, and that's 1,100 square feet. We would take a percentage of one of to the other is 55%.
Of footprint.
Of the footprint. That's one to the other in relationship to one to the other is 55%.
Just for just for the record, why are you pointing that out? Just for the audience out there, why are you pointing that out?
Well, we have a stream of information from every which way. The applications, the first application had a number, the second application had a different number. And then we got information from Mr. Neagle that he calculated his own numbers too, and none of those numbers are what I have here. So in order for the board to be able to make a decision, we have to basically go out there and measure what is there.
I mean, the purpose of a site visit is always to verify the figures were provided in the application, and the figure that was provided for the square footage of the footprint was 1,174.5 square feet, which is different than what we measured ourselves.
Yeah.
And so it's just, that's our job.
So it's 1,100 in there, and what do you have come up with?
1,100.
This is 1,174.
Yeah.
So
And what you come up with?
1,100.
So it's less than what the application says.
yeah.
A second floor.
All right.
You measured from the eve. Yeah.
Yeah.
From eve
Yeah.
to eve, yeah.
Yes, you did.
Furthest point we could find. The
All right. So,
And also, I just may add that relationship, 55% of the primary building, and so it's clear that the secondary building, the garage we're talking about, is not primary, it's a secondary, it's smaller than the primary building.
we have one discussion about this last year.
Right. So,
Okay, I had to introduce this, but there's a lot of secondary accessory buildings in this state that are 3 times the size of the primary.
yeah, but.
So that was before this court ruling.
Yeah, okay.
Right,
So I'm pointing that out, because I
Sure.
want to make that clear.
sure.
That's the story, that's the situation back.
Here, yeah.
Here.
Yeah.
Okay.
So, so with that said, I don't know if the board have any other questions in relation to the application. I still, from the information that we got last night or yesterday, I'm still a little bit, overwhelmed and crunching it. I'm not sure that is relevant to the process of the application, because we have an application and we have the ordinance. And from the court case, we worked very hard last year to, extract what the ordinance needed to, how the ordinance needed to morph to follow that court ruling. We had to do that on our own. We're probably the first court in the state of Maine that had done that. That said, for my part, I'm good with that, and I would like to give the chance to Mr. Neagle to go with us over the documentation provided yesterday, if that will be the case. But before that, Mr. Seal has a question, I think.
Actually, no, that was just gonna be my suggestion, but I would also ask that after Mr. Nagel has presented his memo, we've had an opportunity to ask him questions about it, that Ms. Metcalf be given an opportunity for rebuttal. Because I'm sure she may take issue with some of the information in here.
Okay, so are we in agreement with that proceeding going first?
Whatever you wanna do, that's fine, I'm happy to talk about it now.
Okay, so are you okay with that, Ms. McCaff?
Yeah, as long as I have an opportunity to respond, having just received this, the day before, yesterday or the day before as well.
All right, so if we are in agreement, that's a great thing. So you got the floor, Mr. Neagle.
Thank you very much. Before I talk about the memo, I want to talk a little about the site visit. In my opinion, the building number 1 is a 1.5-story building. And building number 2 is a 2-story building.
Mhm.
It's high up on top of the hill and very visible. And it blocks the stiff's view of Long Lake because it's so big. Because there's a lot of new people here right now, I was going to give you a quick history of what happened last time.
Can, before you go further, that's interesting you say that, because through the site visit, that crossed my mind, the concept that we have a 2-story building there. But if you're there and you level that building to be a first floor building, the steps will not have view of the lake. They will have view of the forest beyond that. You cannot see the lake from there. It's all forest all around. And the trees are so high.
With respect, ma'am,
Yeah.
I stood on the front porch of Stiff's house.
Sure.
Before that was built,
Sure.
and I could see the lake clear as a bell.
I couldn't, because maybe that was 5-6 years ago, and now there's plenty of forest there, but just for the record, I was there. And if you actually will take off that whole second story from the Stiff site, you look that to the north, and all you see is woods. That's okay,
I respectfully disagree with you.
sure,
And I would ask that you let me finish a sentence.
no problem, go ahead.
Thank you. I just want to give a quick history of this building, because there's a lot of new people in the room that may not know this. The Jones built that building in 2018, building 2. With a building permit for a 1-story building with a garage and play. They built twice as much as their permit allowed. The planning board ultimately approved it after the fact, after 6 or 8 meetings. The Stiffs appealed to the zoning board of appeals, which sent the case back to the planning board because the planning board had not adopted any findings of fact and conclusions of law. So we went back to the planning board. At this point, both the zoning board and the planning board had their own lawyers. Planning board then wrote a law. We appealed to the zoning board of appeals, which upheld the planning board. We appealed to the Superior Court, which upheld the planning board. And then we appealed to the Maine Supreme Court, called the law court, short. And you have the decision, it overwhelmingly disagreed with the planning board at lots of different levels. And remanded the case back to the planning board to have the permit denied, which is what happened. The original building permit for this building has been revoked. So the building sits there with no permit right now. And that whole process took about 6 years. And cost both the town and Stiffs a ton of money. Going to all those different boards. I think it's one of the biggest reveals from me is the so-called garage is not being used as a garage. It appears it's being used for storage. And so, you know, I question whether you should call it a garage or a storage area. But anyway, in my view, the videos confirm that both buildings are being used for the same thing. Minor differences, but they're being used to reside in and sleep in. That's what they're doing. It's not an accessory structure as defined, and I'll get to that in a minute. It's an unlawful expansion of their primary residence. Like they took the primary residence, added 3 bedrooms, all good and didn't connect the building. So I'm going to focus on the zoning ordinance, which I'm glad to hear you guys do too. So I think it's really hard to distinguish between the 2 residences. They both show multiple bedrooms for winter and common areas. So your definition of accessory structure in section 17 has 2 prongs. 2 independent prongs with an and in between. 1, the structure has to be incidental or subordinate to the principal use. Got to find that this second structure is incidental or subordinate. And the law court stated that those words mean minor or secondary. I don't think anyone can call the new residence minor. It's taller than the primary residence. I disagree with the way you're measuring floor area. I'll get to that in a minute. But if you've read the decision, I respect you may not want to. They totally dismiss the Jones's arguments. Totally dismiss them. And I believe that removing 1 wall and a refrigerator is not going to change the law court's decision. They can't argue that it's a bunkhouse because a bunkhouse can't have plumbing. And there are some exhibits in the back of my memo, and I want to talk to you about them a little bit. You look at exhibit 9, there are some definitions from your ordinance. And you can see on page 1 of 5 that a bunkhouse is an accessory structure that has no plumbing. So this building is not a bunkhouse. If they take all the plumbing out, it might be a bunkhouse, but it isn't right now. So, and the second prong, and it says and, so it's both for the incidental and subordinate, and the law court's already said it is not incidental or subordinate. And then it goes on to say, given its size, design, and purposes, It complements but does not duplicate the function of the principal use. Well, this second building, building number 2, absolutely duplicates the uses in building number 1. Bedrooms, bathrooms, one has a kitchen, one doesn't. So it is my opinion that because the second building duplicates the functions of the principal building, it cannot be an accessory structure as defined in your ordinance. I'm gonna work right from the ordinance, and videos and floor plans are helpful to understand the facts, but they don't decide the case. So it's gonna be our position if we have to go beyond it. If the second building duplicates the first building, I don't think that's a stretch. And then in court that reads the ordinance is gonna say, well, it's not an accessory structure. It can't be. It does not duplicate the functions if that's what the definition is. So let me talk about square footage. You all have been firm in your opinion that the only square footage that is relevant is the footprint area. And I'm going to respectfully disagree. And I think your ordinance doesn't support that opinion. You may have been doing it, but you have to make your decisions based on the ordinance. So if we go to Exhibit 9 again. And we look on page 3. Again, I copied your ordinance. You will see there are 2 different, there's something called floor area, which is the sum of the horizontal areas of structures. It's how many floors, you gotta count the second floor to figure out the floor area of this house. And then there's something called the footprint area. Now, the application that was filled out asked for square footage without telling you which square footage. And right now, you are ignoring your ordinance and its definition of floor area. And you have decided that the only thing that matters is footprint area. That's the kind of thinking that courts don't like. You can't choose the definition that meets whatever your purpose is. So again, with all due respect, I think you need to consider the floor area because it's right in your ordinance. Nowhere does it say ignore the floor area.
So whereabouts is it in our ordinance?
Excuse me?
Where is it in our ordinance?
It's in the definition.
Isn't the definitions where in the ordinance that's applied?
Well, just because it's floor area in our definition, it doesn't mean it's in our ordinance. Where does it say we have to consider floor area in our ordinance?
It doesn't say yes or no. It has an application that has blanks for floor area. And I have been counting the floor area. I mean, I'm sorry, I should get this application. The application has an area for square foot. That's what it says. What's the square footage? And the STIS filled out the footprint square footage. And they ignored the floor area. Now, I think that's wrong, an incorrect reading of your ordinance. I think you've got to consider both. Because the application doesn't distinguish between them. And floor area, it may not have an impact on the environment. Because the roof, whether it's on 1 or 2 stories, is going to shut off the same amount of water. But the bigger the house, the more people can live there. And the more people that can live there, the more sewage is dumped into a septic system very close to the lake. No septic system is perfect. So increasing floor area increases the risk that there will be some kind of septic system failure. The other thing that's equally important, if you've got more people living in the house, and that's more people going down to the water, eroding the water, it has an impact on the exterior. If you've got one house that's got 6 residents and another house that's got 2 residents, the 6 resident house is going to impact the environment negatively more than the 2 area house.
Can I ask a question?
Yeah.
Can you show us in our ordinance where beyond 100 feet when they limit floor area?
Okay, can I, just real quick, just so you know, in section 12, subsection C1, three I's. It says expansions for structures in the resource protection slope district. If the structure is located in the resource protection slope district, expansion shall be permitted only in floor area or height. Expansion in footprint area shall not be permitted.
That section doesn't apply to this application. This is in a simple,
No, it then goes on to say that in the rest of shoreline zoning, floor area is permitted. Expansion of the footprint is not.
well, it's a question of what's on the app. It comes up on the application. You've got an application that the stiff's filled out. Excuse me, the Jones is filled out. I'm gonna get there, thank you. So there's something that says present square footage. And there's something that says proposed square footage. Now, square footage itself is not defined. And I think your decision to only use the footprint and not the floor area. And as this gentleman said, it is important in the shoreline zone, for just the reasons I stated.
Well, can you show me where beyond 100 feet, where it says that in our ordinance?
Excuse me, sir?
This building beyond 100 feet.
That's a setback, it's not a floor area issue, sir.
That's what I'm saying. So why are you bringing up a floor area? Where's it show it in our ordinance that we have to consider floor area beyond 100 feet? Or anywhere? If
It's
we
on
go
your
by-
application, sir. And I think the reason you have to consider it, at least in this example, is comparing the 2 buildings. Which is subordinate to the other, or are they equal? The Supreme Court has said they are equal.
Well, that's a previous structure, the new one. Here,
The new one is the same structure with one wall removed.
And a kitchen, a full kitchen.
The first application assumed there would be no kitchen.
now, the,
Because the planning board imposed a rule that you couldn't have kitchen. So that,
Yeah, that was wrong. No question about
I
that.
understand that, but the Supreme Court essentially reviewed this building, less one wall.
okay,
Let's
so
just say-
we just went over the numbers. And it seems to me that the Supreme Court was giving the incorrect numbers.
Supreme Court didn't pay a whole lot of numbers to,
Well, they were provided the number by somebody.
I'm just pointing out that we are gonna argue
Sure.
going forward that floor area
Yeah.
is just as important as building footprint.
And it's not in our ordinance.
And, excuse me?
It's not in our ordinance.
The definition is, I can tell you what happened.
Okay.
When we amended our ordinance.
Yep.
And put in the floor area definition. Not the floor area, but the footprint definition. We failed to take out the square footage definition. So that's sitting in there, not really doing it.
Sorry.
Well, I don't see anywhere in your ordinance where floor
The
area,
definition is there, but it's not using the ordinance. The term by itself is not using the ordinance, and we're trying to go by the ordinance to make a decision here. Mr. Seal.
Excuse me, could I finish a sentence without being?
I was talking and I let Mr. Shields speak now because he wanted to exchange something now about what you're talking about. Can you hold a second? Thank you.
Just, I want to build on the context that Rich mentioned. You probably know this as well as we do, that in 2016, DEP revised Chapter 1000, the minimum requirements for shoreline zoning statewide, and eliminated the use of footprint as a and any size standards based on footprint. We subsequently amended our ordinance in 2018 to implement that. We eliminated the standard that existed for many years based on footprint. And basically DEP, as does our ordinance, relies now on the combination of maximum building height and footprint, the square footage, as we discussed earlier, that was asked for in the application, and that in this particular case we took verification measurements of. So I agree with you that the court looked at floor area as one measure of whether or not a building is an accessory structure versus a second principal structure. You know, we'll get to that, I think, when we get to the findings of fact in law. But, you know, we're kind of arguing over nothing here. Yes, you pointed out a possible weakness in our application. Maybe we should be more specific and say that we want the footprint structure, but when applicants come to us, ask us what we want in that space, we tell them we want footprint structure, because that's what there's specific standards based on how far away the proposed structure is from the lake shore. That's the background.
Okay. But the words that we're talking about that apply to this application are both floor area and footprint area. And with all due respect, the reason it's very important is the chairperson here is saying that building number 2 is 51% of building number 1. As if that's a meaningful difference. Yeah, that's true about the footprint, but it's not at all true about the floor area.
Okay.
And can I finish, please?
Sure, go ahead.
Thank you. And there's nothing in your ordinance that says look at one and not the other. Nothing.
Yes, there is. Setback from the water, it's always maximum total footprint. They don't care about floor area.
This is not a setback case. The definition of setback in your ordinance doesn't apply to an accessory use determination.
The first building is non-conforming, and non-conforming structure, they measure maximum total footprint. So that's the number that would be relative.
Okay, Mr. Neal, can I talk now, Mr.
I just don't
Neal?
like being interrupted mid-sentence. Go ahead.
Thank you. So if you wanna totalize all the area in each building, if we go that way, the total area in the one that is number 1, proximity to the lake, is 2,462 square feet. The one total for the away building is 1,953. So it still is 80% smaller. The second building. I mean, even with those numbers that we don't use in our ordinance, is smaller.
My measurement of the floor areas of the,
You have to add all the first floor and the second floor.
that's what I did. And the Jones original structure, the new building has 1,860 square feet of floor area, and the original building has 1,400 square feet of floor area. My point is the new building has 435 more feet of floor area than the original building. I think that's relevant. and-
Those calculations are incorrect.
Well, we can
I can
agree,
share with you that too.
we can agree to disagree. We go on to some other forum.
Well, numbers don't lie. And I have them right here in a spreadsheet. I can show them in the screen if you wanna see them.
Can you agree
Can I do
that?
that?
Yeah, I mean, no. It just, floor area is irrelevant. It just is, I mean.
Okay.
But even by that standard, we're talking about a structure that is 80%.
Yeah, I mean,
Small.
without beating a dead horse, it's irrelevant.
Well, see, he says it's irrelevant and you say it's 80-50%.
She's just entertaining your numbers to show that even with the floor areas, it's still small, but the fact of the matter is, it goes off of a footprint. That's what our ordinance, that's what we go by, that's what I was going by.
Okay, listen, I'm not here to remeasure plans with you. I'm here to present the stiff's position based on your ordinance.
Sure.
And based on the application.
Sure. And we're telling you that we had done the numbers and our numbers are different than yours.
I understand that, and that's okay.
Yeah,
It's okay to be different.
well, we have to be accurate too. And the numbers that were given to the Supreme Court are not accurate.
Okay, well, for example,
If we're gonna be keep talking about measurements and so on,
well, I'm
I-
not, but you guys are.
well,
Okay.
I didn't open the can of worms about floor area. So we are wrapping this conversation now about, floor areas and dimensions. So any other topic that you would like to present in this last, document that you gave us yesterday?
I'm gonna stand by my memo and I respect that you disagree with it, and that's okay,
Sure.
okay? But what isn't okay, my last point, is the Jones have an incomplete application. This is how the system works in your ordinance in every other town that I've worked in. The applicant files an application. You guys review the application for completeness. When you've decided the application is complete, that stops the clock ticking, you get 35 days to make a decision. This application is not complete. So let's go back to Exhibit 8 for a second.
Which ones are up?
You're all found Exhibit 8? My recent memos? It is section C, 16C1. Has a statement that says that every applicant shall submit a site plan, and then it lists 6 or 8 different things. And they don't have those things. My memo pointed out, my first memo of 6 weeks ago pointed out 5 or 6 things in this paragraph that haven't been submitted. And so the application is not complete. And what's worse, if you switch to, if you look to Exhibit 9 again, you see in the definitions of your ordinance, there's something that says what a complete application is. Gotta have a site plan, gotta have drinking water. There's a lot of things, locations of driveways, proposed septic system, they don't show the proposed septic system. Dimension, there are a lot of things, if you look at this carefully, that the Jones have not yet given to you. So you can't, and which surprises me, frankly. The Jones, I assume, are competent people. They can read the ordinance. They read the memo I sent last month saying you're missing 5 or 6 items. Their lawyer could have read it. They just do not have a complete application. If you look at the definition of complete application, you'll see there's many things that are missing. And as far as I know, you guys have never had a discussion about it. He's not lobbying here.
Oh, yeah.
So if the Joneses file an incomplete application, you really can't act on it.
That's
And
what we're
if you
going to do.
do act on it, the ZBA is gonna send it right back to you to do it again. Cause up there, you know, it's just the way it is. And it's frustrating to me, cause you guys keep pointing to the ordinance. The ordinance says this, the ordinance says that. Well, the ordinance also says you need a complete application. The ordinance also says consider floor area. So frankly, I was on the planning board for 12 years. And I understand that it's difficult to deny applications. You guys all want to approve what your residents want to build. That's a given. But when there are egregious cases, in 12 years, we denied 2 applications. One, because the application wasn't complete. Pretty simple. We should have been talking about that in October, but we didn't. So the last thing I want to make, I think, is that you folks seem hyper focused on counting rooms in both buildings. You have to show me where in the ordinance it says you should be doing that.
Actually, in the upgrading that we did for the shoreline zone last spring with the guidance of our lawyer. Let me see how that actually separate here. We said, when we talk about accessory structure or use, we say use a structure which is incidental and subordinate to the principal use or structure and given to its size, designs, purpose, and its complements, but does not duplicate the functions of the principal uses or structure.
So I think frankly, this application is easily denied because it duplicates the first build up. You don't need a ruler or a compass to understand. The video makes it clear, the floor plans make it clear.
Sure.
This building duplicates the first building. Therefore, it is not an accessory structure. Now, the last thing I want to do is, I just want you to flip to page 10, exhibit 10 for a second. Because I know many of you probably haven't read the law court decision. And it's in.
Excuse me, you said what?
Page 10.
No, you said, what you said about the court decision?
I said, I believe some of you may not have read the full law court decision.
I think I made clear with that, we went over that in this board, probably 3 meetings last year. So we all read the court decision.
Okay, well, let me point out some key language. Exhibit 10, page 8. Talks about accessory structure, common understanding of these terms is having a minor or secondary role. I don't think structure 2 has a minor or secondary role. Let's flip to exhibit 10, page 9. Talking about these 2 structures, this is the main court. They say both structures here as built are houses with neither secondary nor minor to the other. So,
Before what is being approved.
yeah, I understand that, and the only thing they've changed is take a wall out.
And a full kitchen.
The full kitchen was gone.
No, I know, but it had a full kitchen when the Supreme Court.
And most of it was
Well,
removed,
plumbing for it at least. It was
and the
seven.
plumbing's still there.
That's a big difference. A full kitchen, you have a house.
Well, listen, what I think doesn't matter, what you think doesn't matter, what the 7 justices of the Supreme Courts think does matter.
Mm.
They describe the law of the land. So when they say they're neither secondary nor minor, I don't think we're quibbling about kitchens. So let's flip the next page. So this is where the law court on paragraph 23 says very clearly, the shoreline zoning ordinance precludes expansions near water bodies to protect the watershed for the reasons I articulated. This second building is an expansion of the first building, same uses. Now, if you think removing the kitchen is gonna change anything, read this sentence. Avoiding duplication by precluding a single activity within one of them, i.e. a kitchen, is inconsistent with these shoreline zoning goals. So here we have the Supreme Court saying, if you take out the kitchen, it's not gonna change everything. That's what the Supreme Court said. And I think you are bound by it. And again, page 14. So the law court doesn't often talk in these absolute terms, but when they say the invitation for a widespread evasion of the shoreline zoning ordinance from an interpretation that would deem a structure accessory if one component of the principal structure were ostensibly prohibited. Their argument is we took out the kitchen, it's no longer an accessory structure. The law court says that's an invitation for widespread evasion. In other words, they don't like it. Without knowing if this case goes back to the law court, I'm pretty comfortable they're gonna say this permit should never have been issued. And what I think you might want to consider doing before you make a decision or adopt findings is hiring a lawyer. Again, what happened last time, the planning board and the code office spent 6 months.
Are you threatening the board?
Not just telling you how the
So why you say that we should hire a lawyer?
to help you make a correct decision that
We have a
conforms-
town lawyer.
Well, you don't have to hire, if you got a town lawyer, there's a town lawyer, I don't care. I'm just saying. As a general proposition. Zoning ordinances are legal documents. And the only people that, in my experience, really understand them is lawyers that practice land use law. Because there are Supreme Court cases that apply to this that you haven't even read. There's lots of tertiary information out there that relates to this. I'm trying to help you avoid making another mistake.
Thank you.
And I really think you're gonna have a hard time getting past but does not duplicate the initial building. I think the videos prove that's what it does. It's the same thing, some bedrooms, some bathrooms, plus a kitchen. That's duplicating. So I really think if you're thinking of approving this, nothing we can do to stop you. But
As I
you
said
might-
before, Mr. Neil, I appreciate your documents and your presentation. We're gonna go by what we have in the application and we have in the ordinance.
Thank you.
Yeah.
And I just want to make one other point. I was unaware of a time limit for submitting additional documents to challenge the application. Prior to the first meeting, Hans asked me not to give it to the planning board till the night of the meeting. which I did. And no one objected to it because of the 7-day limit. Or the Friday before limit.
Okay.
In this case, I was gonna give this to you earlier. But my working assumption was that the Joneses were working on completing their application. Because it couldn't have been more clear if they read the first memo that their application was incomplete. And I asked Ms. Metcalf a week and a half ago, are you going to submit anything else? So I didn't want to submit a memo and then have the Joneses file something else. I never heard back from her. She did not answer my question. And I was thinking, well, they've got, obviously they're gonna file more to make a complete application. So finally, it got to be, Wednesday, and I said, well, I gotta get this to the planning board at least a little bit before the meeting. So going forward, you have more meetings. I will make sure anything I submit to you gets to town hall on or before the Friday before your next meeting. And again, I think this is going to be very easy application to do. Duplication. That's right in the definition that you guys wrote a year or two ago.
Mhm.
Avoids duplication. Can anyone seriously say that the second building avoids duplication? The reason they say that is because people have different sizes of accessory structures for wood shops, for garages, for, I have a long list of things here, hold on a second. Artist studios. Where they go?
Mr. Neal.
But my point is,
Okay,
those things don't duplicate, which
Okay.
is why they're accessory structures.
all right,
You wanna have an artist studio as a second building. You're not gonna have to worry about duplication of uses.
Okay.
If you wanna have a wood shop as a second building, again, you wanna have a garage. There's no garage in the first building. So that's the only thing that doesn't duplicate. But accessory uses were meant to be like bunkhouses, for example.
we got it. Anything else related to this document today?
All I wanna do is thank you for listening.
I appreciate that. So, other than that, is any else that you'll be presenting to this board regarding this application? Because we're closing this tonight in terms of the intake of information.
So you're not gonna allow any more submissions by anybody after tonight.
We have to decide that tonight, but from your, you're saying if more stuff comes in, you're gonna keep talking about it, or I need to wrap, have an understanding that we're wrapping concerns from the neighbors and everything else. Because then the next sessions will be for the board to dialogue on what we have on hand.
Well, I am going to file a response to anything the Joneses find. That's how the system works. The applicant files information. The neighbors file opposition. In this case, the applicant submitted a video and a floor plan. I responded to it. I also responded to the comments at the first meeting that the floor area is irrelevant, which I didn't think was true, and I still don't think is true. So I did my best in this latest memo to respond to issues raised by the Joneses filing and issues raised at our meeting. As of this moment, I think you've done a great job of listening. And if the Joneses never file anything else, then I won't file anything else either.
Okay, so we're committed to that then.
If the Joneses.
And
file
from
anything
here
else-
on, it will be only the dialogue of the board. If there's nothing else that the Joneses submit. From here on, we need as a board, we need to sit down and simmer this down in our dialogue here, and that's it.
Okay, well, for example, you may sit here.
Mr. Jones, Mr. Nigel, anything else besides this today? You said nothing else
Okay.
unless the Joneses provide. So that we are good on that.
I am anticipating that you will decide the application is incomplete. Because it is incomplete. And I'm anticipating that the Jones are gonna found more material to make it complete.
Okay,
And I'm not, and I will respond to that and send you another memo about it.
and your point's well taken. Anything else that you want to provide today?
No.
Providing your condition that if the Joneses provide something else, you will rebuttal. Other than that, anything else that you would like to provide today?
If you close the record and proceed to deliberations, I'm not gonna give you anything else.
So then I'm making sure that once that happens, we're not gonna be dialoguing back and forth. It's gonna be only the board's dialogue.
Yes,
Thank you,
that's the way it should work.
thank you. So, Mr. Seal,
Is it okay for me to ask Mr.
Sure.
Riegel some follow-up questions about his memo? And this is actually, it's only, my only question for you regard, your discussion on page 4 with regard to the application being incomplete, particular paragraph A. Well, paragraph A and B. I have to admit, I'm a little confused by paragraph A because with the exception of the stormwater control measures, which I agree haven't been provided and we deal with as a standard condition of approval because almost nobody knows how to deal with stormwater other than 2 or 3 contractors in this town. We've found it expedient to incorporate DEP's best management practices into each and every permit that we approve for stormwater. But on all other items, starting with the location of the septic system, I mean, that's shown on the septic system design plans that were submitted as part of the application for this latest round. So I'm confused by that.
Well, because they're not shown on the site plan.
It is shown on the site plan. It isn't labeled, but it is shown on the site plan. And if you compare the 2 drawings, you know what you're looking at. The normal high water mark we've already discussed. That's certainly shown on the 2-scale site plan, which is the same as from 2018.
Well, let me make a point. The 2018 application is not on it. I know you looked at some documents.
That's what was submitted to us in the 2025 application.
I understand that, sir.
If I could finish, please. Showing the side views, we have profile drawings to scale that were submitted again within the 2025 application. So again, I'm confused on why the total lot area in the shorelands zone that's provided on the front sheet of the application. So I guess I'm confused as to why you're concluding that this application is incomplete. Now, one last thing, unlike some other ordinances that we administer, like our commercial development review ordinance, there's nothing in shoreland zoning as in the process that we go through or are required to go through where we make a finding and a vote on whether we have a complete application. You're absolutely correct that we cannot approve an application that's incomplete, and I don't know that we've denied any because they're incomplete, but we've certainly tabled a gazillion of them until they were complete. I would just point out as a matter of process, the shoreline zoning ordinance is different than some other ordinances. In that regard, there's no formal process for a vote on whether you have a complete or incomplete application.
Well,
it is an assessment with it that we have to make during our findings of fact in law, but my point being, I just don't understand how you can conclude this application is incomplete.
Well, maybe I put something in there that already was in there, but for example, the DEP person in charge of this, that's a requirement.
There's no groundwork. It's not
Excuse me?
required.
The ordinance doesn't make exceptions. It says, thou shalt follow these things, period. And it doesn't, and see, here's why your your ordinance really is weak. Most ordinances have a lot more application requirements. The one in North Yarmouth, for example, has 30 different application requirements. But the ordinance in North Yarmouth, as do most ordinances, allows the planning board to waive submissions requirements. Your ordinance doesn't. You have to get everything the ordinance asks for. The next time you revise your ordinance, you might consider adding a provision that says, if the board thinks that this particularly submission item isn't going to be helpful, it can grant a waiver at the request of the applicant, but your ordinance doesn't allow that.
Just to follow up on paragraph B, you brought up the issue of the main DEP excavation certification number and name for contractor certified by DEP. Our ordinances couldn't be clearer that that is only necessary when you're doing more than 1 cubic foot of excavation. No excavation is proposed here.
Well, I'm sorry, but there's nothing. I'm just reading the ordinance.
Yeah,
You're
so am
going
I.
back to what your history and experience was.
If you go to the soil erosion control section and standards of the ordinance, you will see that spelled out, couldn't be more clear. So it isn't that we do not have waiver authority. We've been told by our legal personnel that you can't waive zoning requirements. That said, the ordinance is crafted in such a way that we only require what is necessary for the site-specific circumstances of that application. What is being proposed, the site that's in question, what zone is it in? It isn't universal across the board, and it isn't quite as black and white as you make it out to be.
With all
And
due
so
respect.
I again ask you, why are you questioning the completeness of this application? The only thing I see has not been provided to us is a stormwater control plan. And as I've mentioned, that will be addressed as a matter of course, as we do with every application that comes before this board as a standard condition of approval, because we've found most, with the exception of a few contractors here in Belgrade, know nothing about stormwater management.
Well, all due respect, your ordinance says they shall file a stormwater runoff control measures. The applicant, the Joneses, shall file this stormwater plan, and they haven't done it. Plain and simple. They have not done it, and you can't say, well, they don't have to file it because we'll deal with it later, which is what I thought you just said. That's not, ordinance doesn't give you that power.
Can you tell me which section of the ordinance is what you read, please?
He's quoting correctly from the stormwater management.
And frankly, when I
standard.
wrote that list, I hadn't even discovered the definition of a complete application, and I haven't really had time to pick through that one round at a time, but your definition has more things than that section does.
I think we're going to just have to leave it at that, agree to disagree as to what authority the planning board has and does not have with respect to addressing something like stormwater management that may be the one item lacking from this application. And
That's fine.
whether or not we can deal with it through a condition of approval or not. So why don't we leave it at that? I think we disagree on whether or not the board has a complete application. Again, I feel we do.
All I can say is, when judges read zoning ordinances, they read the words. They don't care about the history of the words. Unless they're ambiguous. They read the words. And if it says file this information. Nothing in this ordinance or the common law that I've read gives you the right to say, now you don't have to file it because we don't think we need it, or we'll deal with it later. What should have happened here in theory, and it didn't happen, and that is the only blame there lies with the Joneses. They did not even try to file a complete application. Because again, on page 52 of your ordinance is the whole definition. You guys keep wanting to do the Joneses work for them. You should say to the Jones, there's no stormwater application, please file one.
I will say a comment about that, Mr. Neagle. This board is made of volunteers that are placed in this position to administer, if you would, the ordinance as applications do come. People come here not knowing how to fill the application. We have to help them through that. You're trying to tell us that to be real board, we're gonna negate a resident the ability to help them to walk them through an
Negate what?
application, the ability to help them and explain them how to go about the application. That's acting in bad faith.
Oh, I think you should work with the applicants.
And that's exactly what we're doing, acting
Well,
in
but I
good
think you
faith with
should
the
say-
applicant.
I think you should say to the applicants, here's a list of what you need to file, right in this book. Make sure your application has all.
And that's what we do. And when they have questions and their disagreements about numbers, we try to settle that down in good faith.
Okay, well, I don't wanna get.
What I heard from you exactly is that we're not here to help the applicant. That's acting in bad faith.
I didn't say that.
Well, it's on the record. So
I said.
we are being recorded.
Didn't use the words bad faith, man.
No, but you said that we should not be helping the applicant, that the applicant is supposed to finish the application. And I'm not gonna go deeper into that. I just wanted to say my say about that,
I respect it.
all right?
I respect it.
And we're done with that.
Can I just add one thing, just the words are important, right? And yeah, you know, we've used duplication a lot, and duplication isn't in our ordinance very much, but it is in section 12. And it says the exact or nearly exact reproduction of a lawfully existing principal structure, whether accomplished by reconstruction, replacement, expansion. Right, so it's the exact or nearly exact reproduction. That's actually in regards to like if the house is to burn down and we're gonna rebuild it. But that's the only time that I can find duplication in all of our ordinance. But
Well, I would point you to the definition of accessory structure, which is what we're talking about. And the definition says it complements but does not duplicate.
correct.
There it
I agree.
is.
That's why I chose that definition. So then it's saying exact or nearly exact to the principal structure. If we're going by the only,
Well, I don't know where you
Duplication
got the
def-
exact or nearly exact.
that's in section 12.
Otherwise,
It's in regards to reconstruction, if like a house is to burn down.
we're not reconstructing it.
No, I know that. I'm just saying that's the only time duplication, the word duplication is in our ordinance. And
Again,
again,
I
it's in regards to that, it says the exact or nearly exact.
That definition doesn't apply to this application, because they're not rebuilding a house. This application deals with the definition of accessory structure, which again says shall not duplicate.
Correct. And
And
then
I don't understand why you're telling me the word duplicate doesn't appear in the ordinance.
no, it does, is what I'm saying. In section 12, it does. It's defined as exact or nearly exact. It's the definition of duplication in
Duplication.
the ordinance.
That's not the definition we're going by, sir.
Oh.
If you look at the definition of accessory structure or use,
No, I know, it uses the
We're,
word.
we're talking about the word
I'm talking
duplicate.
about the word duplicate. It does appear again in our ordinance in section 12 definition of duplication, and the words you use, the exact or nearly exact.
That's in the context of rebuilding a house.
Correct. But
Okay, well, we're
I'm
not
just-
talking about rebuilding a house.
No, we're just talking about duplication.
We're talking about whether this structure, the new structure
Mm.
that was built without a permit,
Yeah, I just wanted to add that to the record.
okay, does it or does it not duplicate the initial structure? That's the bottom line here, you know.
To figure out whether that does, we need definitions, and the definition of duplication is the exact or nearly exact.
No, I respectfully disagree with you, sir,
Oh, I mean, we can't that's what it says in the ordinance.
but you told me it only applied to the rebuilding of structure.
No, that's where it's defined in regards to that,
Can you give me
that situation.
Clerk, please?
I believe it's 12. Section 3,
Excuse me?
section 3. So. Definitions list. But it's usually, it's mainly used in section 12,
On non-conformist,
non-conforming structures, yeah.
we're not talking about non-conformist.
No, I get,
So the definition in the section is not relevant to this application. That's my opinion.
okay.
And I really think that my picture of the application and plan. I think what you gotta ask yourself is, does this building 2 duplicate the uses in building 1? You need to answer that question. And if you want to say it doesn't, that's your prerogative. But I think it's a high position to hold given the videos and the board.
Sounds good. So I think, we have, Mrs. Metcalf.
Thank you. I'd be happy to talk with you, and I hope that I won't keep you here very long. I want to go first to the notion that the application is incomplete. Under your ordinance, it states that the determination as to whether the application is complete or incomplete needs to be made by the CEO or the planning board, and the decision needs to be communicated to the applicant within 35 days. So this application, which is on your pre-approved form, contains the information that you were seeking. And as Mr. Seal has just indicated, many, many things in the file as part of this record and attached to these agenda items answer those questions. In that context, it's perfectly appropriate that neither the CEO or the planning board notified the applicant within 35 days of July 15th that the application was incomplete. You have the information you need in front of you to determine whether or not you can make a decision. That's the point of completeness. Do you have the information in front of you? As Mr. Seal has just noted, if you feel that there might be some extraneous or additional material that you might want to think of, that same section on the 35 days says you can attach a condition. Erosion control is not likely to be an issue here because this structure is going to be altered if this permit is allowed by removing the wall, confirming the removal of all the cooking facilities consistent with the law court decision. So this is a red herring. If this application was incomplete, we would have known about it. In terms of the submission of additional material, the additional material is specific, namely the videos and the floor plans. They were submitted to you on November 21st because I was mindful that you want things 7 days prior. And so we got them to you 10 days prior because we knew that you would want to be able to look at these things prior to the Thanksgiving holiday. And I appreciate that it is obvious that all of you have looked at these things because you've asked some very good questions throughout the course of this evening. I think what's very important here is to remember that the law court made a decision and you analyzed it and you revised your ordinance. And you now have a new application in front of you, which addresses the revised ordinance. The accessory structure provision that the law court was analyzing was a different accessory structure provision. More importantly, all the language that Mr. Nagel has just directed you to is what we lawyers would call dicta. It is the thought process by which the court made its decision, but it is not the holding. The holding of that court decision was this wasn't a proper accessory structure because attaching a condition to make sure there were no cooking facilities in this building was not sufficient to assure that there would not be a cooking facility there. And so we've scratched what cooking facilities are. We're taking all that out. So what does your definition of accessory structure now say? It doesn't simply say that it does not duplicate functions. Indeed, as you all noted, many of you noted in your October meeting, it would be absurd to suggest that if a house has 2 bedrooms and someone wants to add 1 bedroom, you couldn't approve that building permit application because a bedroom duplicates other bedrooms. There is no statement in your ordinance that says there can only be X amount of bedrooms. There is no statement in your ordinance that there can only be X amount of bathrooms. What this new definition states is that the accessory structure or use, given its size, design, and purpose, complements, but does not duplicate the functions. And I would suggest that everything you see in the videos and in the floor plans that we've provided you and in the application shows that that definition is met. The accessory structure complements, but does not duplicate the functions. We have a landing area that can become a sitting area. That doesn't mean that it duplicates the living room. We have a bathroom on each floor, and we have a bathroom on each floor in the other house. It doesn't dwarf the structure, it complements it. A 4-bedroom house is something that you or I might not have, but it is not forbidden by your ordinance. The fact of the matter is this accessory structure that we're talking about today is in fact an accessory structure because it cannot stand on its own without the existence of the principal structure. There is no kitchen. There will not be any kitchen. You can't live in a house in this modern world without a kitchen. This complements, it does not overwhelm or dominate the principal structure. In fact, it says that the accessory structure shall not subordinate the principal use of the lot. That's your definition. And certainly, given the fact that the principal structure has the kitchen where people live and cook and eat, there's no reasonable argument that the accessory structure dominates the principal structure. This is a structure that is used for family. This structure, when the bedroom wall is taken out to assure that there are fewer bedrooms in the second building than in the first building, and to assure that there's a counter that will never be there and cabinets that will never be there and cooking facilities that will never be there, we accomplish the definition. I think that Mr. Zaharro is correct. Just as the law court said, and just as any law court would say, sometimes you have to look to ordinary language. What is meant by ordinary language here? Well, we know that duplicate under accessory structure says that it complements but does not duplicate. But we also have in your ordinance, in the context of a replacement structure, when there's a fire or other cataclysmic loss of a structure, you have an indication of what you as a community mean by duplication when you drafted and accepted your ordinance. Duplication means exact and nearly duplicates. And section 12 says that. So is this accessory structure a mirror image, a carbon copy of the principal structure? No, it is not. You know that from your measurements, you know that from your math. I appreciate the care that you took in doing your math, both at the site visit and in the work that you've done today. I think that what we've heard is a lot of complaints that the Stiffs do not want to have this building there, but none of those reasons are are supported by the ordinance. They complain that their view is blocked. As you noted, Chair, that is not consistent with my observations on the site plan, and it was not consistent with yours. But in any event, they don't have a view easement. And this area, this forum that we're in, is not the forum at which that is dealt with. The floor area, Mr. Nagel argued that it was relevant, and then he argued that it was irrelevant. But in either circumstance, the math proves that in accordance with your accessory structure definition, the second building, what we call building 2, is subordinate to, smaller than, does not overwhelm the other. You have been very patient all through October in taking that careful site visit that you took and listening for the last 2 hours. I would be happy to answer any specific questions that you have, and I think this application is in order for decision.
Thank you. Now, are you gonna be supplying any more information of any kind to this board in order for us to consider the application?
Now, I understand that I would say pleadings, that the files would have been supplemented if we have been told that the application was incomplete. We have not been told that. We have supplemented the files with what you asked for. If you ask us for something else, we'd be happy to try to provide it. We are here to provide you the information you feel you need to act on this application.
Okay, so just like I explained before here, once no more information is given, we're closing it, and then the dialogue is among the board exclusively.
Understood.
Thank you. So, do any board member want or require or like to have any additional information besides what we have here?
A question for the board. This goes back to the point, Mr. Nagel's point about the stormwater management control plan. Does anybody feel like we need to require the applicant to provide one rather than, as we have always since 2016 or 2018 when that was added to the ordinance, to rely on our standard condition of approval, and that would be adequate?
I think if the ordinance says it should be there, we ought to require it, particularly since somebody's objecting to us not taking it.
I'm just thinking, do we have something to give to the applicant as to what they need to say, or, the verbiage, or what? I mean,
You remarked that there's no excavation proposed in the application, that it doesn't apply.
Yeah, this is with regard to the stormwater management plan, not the soil erosion control plan, or the need for a DEP certified excavation contractor.
Right.
So this would deal with the runoff from the roof, the runoff of other impermeable surfaces associated with the proposal, as is as is required by the ordinance. I mean, it was clear to me at the site visit, my most recent site visit, that there are no such measures in place. So my question is, do we vary from our historical procedure of relying on a standard condition of approval that all permits that we issue have, to meet the stormwater requirement, stormwater management requirement. Rich has said the ordinance says a plan should be submitted. Nobody's ever submitted a plan to us with the exception of 2 or 3 contractors in town that do it pretty routinely.
Right, and I just, you know, I think it's a good point, and if we're gonna do that, we need to make it user friendly to the applicants going forward. And that, you know, we're looking for plan, you know, we need to come up with some kind of verbiage that they could use. And
You know, I'm sorry, I didn't answer your question. You're right. We don't have a template,
right,
if that's what you're asking.
Yeah.
What we do have is, and what the ordinance requires is that it be consistent with DEP's best management plans, and it gives a reference, and we even have that information on the
Right.
town website.
So they have a guideline, if we will tell the applicant to go on. provide it.
Wouldn't that have been submitted and approved on the first application of construction?
It wasn't, no, there was none then submitted or and hence why there's still no, stormwater control measures in place as we observed at the site visit.
So,
Are you suggesting a condition?
No,
No.
I'm asking the question of
we should ask the applicant to.
whether or not we should ask the applicant to provide a stormwater management.
I would agree with what Mr. Baker said. We never had an issue before, but because there's an objection now, we should probably ask the applicant for it. You guys want to vote on that?
I will say, if we decide to require, stick to the black and white of the ordinance and require a plan in this case, just like with the soil erosion control plan, which nobody submits. I mean, we're talking the real world here, okay? Not the world that the Supreme Court lives in, okay?
With all due respect, Mr. Steele, the Supreme Court lives in the real world. There are real people on it. And for you to suggest.
But where the boots meet the ground is here,
Is there-
not in Portland, okay? And, I never mind. It's all relevant. That from this point forward, we require it of all other applicants. If we're gonna treat, regardless of the fact that this is a more controversial application than almost all we've seen since I've been on the board, which is over 10 years. Well, with one exception, I think we need to treat everybody equally.
I agree. I guess my thought is, if we don't require it, and we haven't been, why do we have it in the ordinance that they shall provide it? And then just say, well, we'll do it afterward.
Well, we can change the ordinance after this.
To
But-
be fair, right, like you said, moving forward,
Yeah.
we should do that. But I don't know is it fair to the Jones to make them submit that now when we haven't made anyone else submit it? So if that's something we agreed on, then that's fine. It's in the ordinance. I think we should. But I would suggest moving forward, because now you're punishing the Jones when every other application came before us, we didn't make them do that. So you're not really being fair.
So let me ask a question. So submitting a stormwater runoff plan. Isn't it fairly basic, because the DEP best practices are pretty basic,
Right.
stone, drip edge line. And.
Well, as you know, when we've had something submitted to us, that's what it's been, and it's shown on the site plan. And so that meets the requirement of having submitted a stormwater control measure or plan. But as you also know, there's only 2 or 3 contractors in town that do that, and most applicants that come to us don't. And so that's why I mean, the evolution of this is nobody was submitting plans, so we came up with a standard condition of approval to make sure the meaning of the spirit and the meaning of the ordinance was met, even if the letter of the ordinance wasn't being met.
Okay, so then, do we have to have, we don't have to have both that, we just gotta require.
I think we've heard multiple opinions for that board. I would suggest having a vote.
Well, okay,
We need a motion.
so,
Yeah, but what's the motion gonna be putting a condition in that we verify that they have, well, allowing them to prove the stormwater management system that is currently in place, because this isn't new construction, there's something that's already here.
Yeah, there is nothing there though.
It would need to be required.
It'd have to be required.
Yeah, so I guess the motion would be, and I'll just make it,
Yeah.
just to move things along.
so before going there, you guys think it will be, consensus, to ask Mrs. McCaff what she would think about that? Cause she can say, well, you guys are not required for anybody else.
Well, I mean, the fact of the matter is, did we notify Ms. Metcalf or the Joneses that the application was complete or incomplete? No,
Wait,
we didn't.
well, no, we're gonna figure that out now.
Yeah, not within 35 days.
We agreed that you could have more than 35 days, but that was 6 weeks ago. I mean, all due respect, no one's being punished. And the fact that you guys didn't enforce this provision for a long time doesn't mean you should keep doing it.
Point of
agree with
order.
I
agree with that.
completely agree with you on that one. Yeah,
So.
yeah.
Do
May I raise a point of order?
something, Judy Metcalf gets to decide whether or not she wants to submit.
Yeah, but there's a point here, Mr.
My point of order is, as I understand it, that the public portion of this meeting has been closed, and this is dialogue amongst yourselves.
No, we had not gone there yet. I just,
Well,
I-
Ms. Metcalf should get an opportunity to weigh in as well.
okay. So I'm sorry about that, Ms. McCann. When I asked today if you needed anything else to submit, I just want to make sure that something else from the application was not coming in. But we had not quite closed that circle yet. All right. So that said, we are dialoguing among ourselves, and this is how we go about this. And we had a history of treating applicants, because most people don't know any about these things, come here and they lost into it, and we have to help them to comply with the application process and the ordinance by providing a condition of approval. Okay, so because we are now challenged to meet the letter of the ordinance, we are gonna possibly request from the Joneses, your clients, to provide that plan. And before going and voting about this, I think it would be fair to hear how you feel about that. Because this very first time ever happened to us. So the question to you is, we are gonna be pressing the letter of the ordinance with your application, because we never had an objection before. Do you think it will be it be something that the Joneses would take fine, or would get upset about it, or I just wanna have a feel for that. Not that your
I would-
opinion will change our command or not, but I just wanna hear.
Yep, I'm happy to answer that question. First of all, the Joneses are very grateful for all the time that you have devoted to this process since their application was submitted. We did not hear any type of communication that the application was incomplete. And so when we went forward with the the hearing in October, we were prepared to have the decision made in October. We also did not hear from you in October that the application was incomplete. I know that following the letter of the ordinance is something that is important. It has always been the intention of the Joneses to do their very best to comply with every aspect of this matter. I think that the Stiffs and their attorney have made very clear that no matter what you all do to try to protect the record, they're going to challenge whatever you do in any event. So my clients will obviously comply with any request that you make of them. If you would like to table this application again until a stormwater management plan can be submitted as an additional element of this, they would listen to that. If you want to attach it as a condition to an approval, if that is what the board wants to do on this application, they would comply with that. We have every intention of adhering to what you would like us to do in the event that you approve the permit, or if you want to table this permit one more time. It is up to you. Our single-minded goal is to comply with the ordinance as written by you.
All right, so,
One quick point.
one second, I own this meeting, all right? I decided who talked, right? So I'm gonna say something about that. So in regards to the timing for when the application was submitted and so on, we agreed in October, what was it, October 16? That when we had this meeting, the first meeting about this application, we agreed to meet now, so it would have been 2 weeks, not a month. So I think the concept of considering the timing, the days between October and now, it would not be a fair thing, because we all agree, the three parties, the applicant, the Stiffs, and ourselves, to have the second meeting today.
In terms of us making
Deciding if we're gonna
a
table it.
decision, I
or-
agree. The requirement for us to notify the applicant if the application's incomplete is 35 days from date of submittal, which was in July,
Okay, so then
So,
she
I believe. Correct me if I'm wrong.
can I just add one quick point?
just hold a second, let's see what this CEO is gonna say.
Well, I'm waiting for Hans to.
So,
So
Mr.
Judy said she didn't know about the stormwater thing till tonight. It was in my October memo. That the fact that the Joneses had not yet filed a stormwater application was in my October memo. This is not news.
My
I
point was
understand
that
that,
I
Mr.
had
Nagel.
received no direction from the board. We do not take direction from Mr. Nagel.
You take my words out of my mouth.
I don't give directions. I simply read the ordinance.
Yeah,
The
but
Joneses could have done.
but the bottom line, Mr. Nagel, is that call comes from the board.
I understand that.
Yeah,
I'm just pointing out
and the applicant followed what the board asked them to. Thank you. You find it?
Yes, section 16C3, all applications shall be dated. And the code enforcement officer or planning board as appropriate, so planning board is appropriate here. Shall note upon each application the date and time of its receipt. He didn't receive it until October meeting.
Okay.
Planning board received. But 35 days from October 16th.
Yeah, but again, we agreed not meeting in 2 weeks from there. We agreed to meet now.
Yes.
So counting the days should have been like 14 days, actually.
Show that.
Yeah, so then, that said, then we're good then. With deeming the application quote unquote incomplete and table it till we get that information.
Oh,
No, okay, yeah, but in terms of the timeline thing, we're not out of the timeline, so to speak. that right?
Yeah, no, I stand corrected, on that in terms of, the 35 days.
So we're still good.
It's, or close to it. I mean, again, the meeting this was delayed on our agenda until this meeting to accommodate, I believe, Mr. Nagel schedule. I would, it seems reasonable to me.
Okay. So, Mr. Nagel, you had a question?
I forgot to comment on something I want you to be aware of.
Sure.
Jeff Stiff drove up from Virginia to attend this meeting.
Okay.
Because he wants to protect his investment. He drove up from Virginia for the October meeting. Find it interesting the Jones don't show up at any meetings. Just an observation.
Note taken,
Thank you.
right? So, so we're gonna do a vote? Go ahead.
Let me just add an option that I haven't thought of until this Metcalf mentioned it passing, and that is that. So I see three avenues forward. One is we stay the course and rely with respect to the stormwater runoff management on our current standard condition of approval that's in all permits that we issue. Our second option is to require the submission, to table the application and require the submission of a stormwater management plan in accordance with that relevant section of the ordinance. In this case, it would be that homeowners, DEP's homeowners, conservation manual or something, whatever it's called in the ordinance. And our third option would be to, again, address this by condition of approval, but that the condition of approval not be our standard condition of approval, that we substitute for that condition of approval for the submission of a stormwater management plan for planning board approval. That only really is an option to be considered if we want to wrap things up tonight. So I just point that out.
How do we determine which of the three?
Well,
Vote on
I can tell you my opinion. My opinion is that we table and required plan now because this is going to court. Doesn't matter what we do tonight, this is going to court as far as I'm concerned. And so we need to lay down the best record to protect the town's interests as we can.
Agree. You want to make a motion?
Yeah, I'll make a motion that we require a stormwater management plan consistent that meets the requirements of
Section 16.
yeah, section 16. I was trying to come up with the specific not section 16, but uh 15I stormwater runoff. I subparagraph right, the I 15I stormwater runoff. So the motion would be to submit, request the table the application and to request the applicant to submit a stormwater management plan that meets the requirements of section 15I, stormwater runoff. That is based on, as required by the ordinance, DEP's conservation practices for homeowners.
May I point out that stormwater runoff in 16I1 only applies to new construction? So the Joneses are gonna say this isn't new construction, I'm not giving you a plan and it complies with section 15. But I think you need to reword your ordinance if you really want to file a stormwater plan.
Well,
We're not going to say that. If that's the condition, we won't say, remember, we're treating this as though the building doesn't exist, so it would be deemed to be new construction.
Thank you, Judy. I have no problem with your motion.
I second it.
Right, we have any further discussion on it? For everybody here, please, I will remind you that if we listen to each other by taking turns and I decide we take whose turns to speak, it will be a lot better. The whole meeting will go in a good flow. I appreciate it. So we're gonna vote. Mr. Sakara?
Yeah.
Mr. Sargent?
Yes.
Mr. Seal?
Yes.
Mr. Alexander?
Yes.
And Mr. Ranget is 5 in favor and 1 opposed, so motion carries. So, Mrs. McCaff, we're gonna request from the Joneses a stormwater plan, all right? Stormwater management plan. And so that means that the application is gonna be, well, now it's being incomplete, but we're gonna table it till that plan is submitted.
Just for your information, and we tell this to all applicants, we have a link to DEP's best management practices on the website. If you go to the planning board, it's on that same page.
Thank you. Yes, you had mentioned that earlier. I appreciate it.
And obviously, if you have any questions, feel free to call Hans.
I really appreciate your flexibility. Now, Mr. Stiff, in regards to your attendance to the meetings, will you be comfortable with doing this? I hate the concept that you're blowing your bucket and making all these trips. I mean, we offered you to be able to join us through Zoom. If that's a something that works for you, I would love to engage with that. I think maybe let's talk about when we're gonna meet again. I'm not sure that I mean, traveling gets dicey coming through the winter. I don't know what would be the best date for you guys, for Mrs. McCaff and you. We are willing to work around that. I don't want this to become a hassle to any of you in transportation or attendance or whatnot. So.
I appreciate Kennedy giving me that option,
Sure.
but growing up in New England, I still know how to drive in the snow.
Okay.
So, appreciate your concern.
Sure.
As you can see, my wife is signed on by Zoom.
Yeah.
And appreciate the technology you think available.
Sure. So, let's talk about when next meeting will be in 2 weeks for us. And that will be the last meeting of the year. With that agenda's full.
There's items on there, but we have to talk about housekeeping anyways, as far as the first meeting in January, because it's the first.
Okay.
So
No, we don't want, we don't have a meeting on the 1st of January.
there's 5 weeks in January, or 5 Thursdays. So we can just go 2nd and 4th, or the 3rd and 5th.
But
And I feel like that might be a better time than December 20th. Especially Mr. Stibb. Wants to drive up here, that's the holiday traffic.
What do you think, Mr. Stiff? You had the longest drive.
I'm available if you are, so.
Same here. My
Okay,
drive's only an hour.
so,
What's the board decision about January meeting, so we're gonna go,
so our next meeting will be. Today is the 4th, our next meeting will be on the 20th, on the 18th.
we have things on the agenda,
Okay, so that, we cannot do it on the 18th.
not gonna push it back again.
Okay,
Can I make a suggestion?
go ahead.
The second and fourth. There's 5 weeks, the second and fourth. That way we're not back to back with the fifth and the first.
For January, second week and fourth week.
Yeah.
You guys are okay with that?
Yeah, as long as they have plenty of time to get the,
That's plenty of time.
yeah.
I'm not available the second Thursday of the month. I wasn't, remember,
Yeah,
we had that issue,
yeah,
but I'm an alternate, so I don't know if that makes a difference.
and we, you had the secretary too, so, well, you can watch the videos to do that.
Yeah.
Yeah, okay. So-
That's just a suggestion.
Sure.
I mean, that's.
No, but since I don't hear anybody saying no, besides Mrs. Morale, we probably will go to that. Let's see what Mrs. Metcalf got to say.
Well, I just want to make sure I understand what you're proposing. You're proposing January 8th as the meeting?
Yeah,
Okay, that works.
okay. It works.
I'm happy with it.
All right,
Sooner the better is.
okay, January the 8th. Everybody else,
Come on.
we're on it. All right, so we got a date, January the 8th, this next meeting.
I did want to simply respond to Mr. Nagel's suggestion that the Joneses' failure to attend somehow is meaningful. As I mentioned in October, one of my clients is recovering from serious surgery, and they are mindful that they have the Zoom option. They're appreciative of it, but they're both very hard of hearing in any event. And so they have engaged me to assure that I answer all the questions. They have a deep interest in assuring that you are comfortable with this application.
Thank you. So I guess we're good for January the 8th.
What's Mrs. Stiff wants to say?
Yes, Mrs. Steph, would you
Well,
like to say something?
thank you. And truly, you all have committed so much time, and I know you're volunteers, and I know you have concern for the community, and I'm just overwhelmed, quite honestly, sitting here in Virginia, because I did not make the drive to Maine tonight, but I did kind of compose some thoughts, if you would indulge me. So the application tonight cannot be seen in deniability of what was built. What was built gives access to a full kitchen, laundry, 3 bedrooms, paneled finished garage, 2 baths and family room, duplication of the original cottage. So the modifications is worthy, the worthiness of review of it is problematic in so many ways, as our attorney expressed. It's a bit of a ruse to think that a proposed minor modifications make it a second new accessory structure. You all have an opportunity at this moment to make a statement to people who abuse building permits in Belgrade and possibly beautiful lake regions throughout the state. Your board, in their decision, can choose to have an instrumental impact in ways that protect our lakeshore development for posterity, or you can give a green light to abuse for future development, which I don't think you want to do. I ask you all to be forward-thinking, visionary, and courageous. You truly have a responsibility on shoulders at this moment to decide upon an issue that has deep significance for our region. You even refer to the sense that this is going to court. My question to you all is to do what you want to be, leaders who have significant impact, to protect a region from overdevelopment and off-season abuse of permits? Or do you want to send a message that Belgrade is a place where a building is welcomed only when buildings conform to state and local regulations as viewed by diligent CEOs and based on clear and accurate building permits, not blurred by homeowners assertively exceeding the parameters of a building permit? This case truly has significance, and I know that you all know what that is. I've prayed that each of you will heavily and thoroughly weigh how you want to see our community grow, thrive, and survive for the future and for our progeny in the century. For this case will have that kind of long-standing impact, and I know you all know that. All that being said, my husband and I want you to know that we do truly deeply appreciate your service to our town, and in particular to this case. It's not been an easy road for any of us. You all are volunteers, as you alluded to earlier. We are honest people who expected our neighbors to be honest and build a structure based on their original permit. That's why I truly don't have a lot of sympathy when the remarks are made about, oh, the poor Joneses. Anyway, editorial comment. They duplicated their second structure. It remains a duplicate structure by potential use. You are never going to oversee what will not occur in the future in that structure. So we just ask you to honor this abuse by denying their permit proposal, although I know that's not what's on the docket for next month, and require them to modify their structure to be the one-story structure that they originally permitted, even though we're 2 permits down the road. And truth be told, like it or not, we just know it's not easy to, as the saying goes, man up, but we're truly asking you to in a respectful and heartfelt way. So thank you. We so appreciate all that you've given to this, and we know it is above and beyond anything else on your docket. Thank you.
Well, Mr. Sip, I really appreciate your words. And I want you to understand that we're trying very hard to follow the ordinance and to accept the application as is proposed and deal with it through the ordinance, and we'll see where all that fills in. We know the ordinance is this and the application is this. Sometimes it's passed, sometimes it doesn't. So to the best of our abilities, we're gonna comply with that.
Thank you.
You're very welcome. So that said, I guess we're good. Thank you so very much.
Thank you.
Yeah.
Thank you very much for your time. Have a pleasant holiday. Merry Christmas to you all.
Same to you all. Thank you.
Like I said, I was on a planning board for 12 years. I really appreciate. We had long meetings too. The town is a better place than what you guys are doing.
Thanks.
You keep referencing one-story building permit. Can you provide a copy of permit that said
I've
one
already given
story?
you a copy of it.
It says one story on it?
It's
It
just,
does not.
it's just no, yeah.
No, it doesn't say how many stories,
Okay, then.
but it says a garage and a playroom and a.
Well, it must specify the height though, in the application, no?
Well, it said playroom.
And the one story.
We,
Sorry, sir, I respectfully disagree. I mean, it's obvious. The first floor of their plan is essentially what they're trying to build. A garage with a playroom,
And wash and
and
dry.
that's on one floor.
It didn't say one. floor.
that's the thing,
Doesn't say two floors either.
Mr. Neal-
I think this is where common sense comes into play.
No, it's-
well, it's, things we have to deal, from the documentation, what is in the paper, in the record.
Okay, so.
And I-
Gave the layout of home.
Sure.
Whether it's on one
then-
or two stories, it didn't have 3 bedrooms, a kitchen, and 2 bathrooms in it.
Is there a layout of that application?
Yeah, they didn't provide a print or anything.
They did.
Well, the original one was 26 by 26, but then they built what they built.
Yeah.
So, I mean, they went off the reservation on the first permit.
Yeah.
And then,
I had squeezed out myself trying to look for that piece of paper that shows 2 stories or 1 story. And
It doesn't say that, it just says garage with playroom
but did,
and.
And the handwritten layouts of the first floor.
and that's the one that Gary approved.
where's the hand? There's only 1 page with the handwritten permit. Where's the drawing of the site? I have not seen that.
Where's Gary's files? Cause he had it, and I remember seeing it myself.
I think I may have a copy of it back in my office.
That'd be great if we did.
But, you know, I'll just make this point. Whether it was 1 or 2 stories, the Joneses built something twice as large as what they applied for. And what's amazing to me is this town, they got away with it. This town didn't fine them, they didn't take them to court to shut it down. The town just ignored it. And I don't think that's, I hope
But
you
that-
guys can change things.
That's a big assumption there that the whole town didn't care about it.
Well, I can
Okay.
show you a settlement agreement that the Jones tried to work out with the town manager. And they were gonna go forward with it until I told them they had to take it to the town council. So back in 2019, the town was doing its best to support the Joneses. And fortunately, the town council told them they had to go to the planning board. And that's where this all began. The point is, they abused their permit, and they've never been held to account for it, ever.
Well, that's your opinion, but that, I mean, this is all wording. We unfortunately, we have to go, well, we have
Yeah,
the
you're right.
evidence.
But I'm just
What is in the
saying, big
paper and it's
picture,
record.
My town, if someone had done that, code officer would have sued him and forced him to take the building down.
May I, point of order, are we through with this discussion?
Yeah.
Yeah, we are.
Yes, we
That
are.
this extraneous irrelevant material is off topic. Merry
Yes.
Christmas, you all. Thank you.
Thank you, Green.
So,
If you.
A good drive home.
Yeah.
A good drive back.
I have never seen, this is one of the windiest days.
it was windy outside, so it was absolutely crazy.
I got behind a, big truck. Ooh. Going back and forth, then had no control over the thing. Fortunately, I had a little powder wind doesn't do it.
George, can I ask a favor?
Drive safely.
Yes.
Thank you.
Go slow.
I want to look at the motion, make sure I haven't.
Well, isn't the recording? It's in the recording.
It's recorded.
But they don't put the motions.
Oh, you gotta watch it, I guess.
Yeah, and that, do you know how long that takes? I don't mind, but, yep.
Well,
Well, you don't.
just go to 2 hours and 2.5 hours in. And,
I mean, I know the gist of it. I just don't.
I can read it to you and see if you would.
Yeah, why don't you do that?
Okay. You're asked to request the stormwater plan consistent meets with the requirements of section 15I stormwater runoff. We're gonna table the application request. Application submit based as requirements of the ordinance.
With DEP.
Yeah,
Yeah.
some of it got garbled a little bit. So, yeah, I mean, again, I don't remember my exact words, but the gist was that, the board required the applicant to submit a stormwater runoff management plan in accordance with section 15I. And that we, table the application, at this time. And it'll or something to that effect.
What based as requirements of the, yeah, we don't need based as requirements of the ordinance, no,
No.
okay. Scratch that, got it.
Okay.
Why are we
So,
having a January 8 meeting? Are we having another one in December?
no, we,
Yeah,
is,
Yeah.
the first Thursday in January is January 1st.
Yeah, right, but are we having one more in December?
No,
Yes.
oh, no, no, never mind, yes, we do.
Sorry. It's only not 10 of 9.
The thing is, the next meeting, Mrs. Morel, the next meeting is packed, so we have a full agenda, so we couldn't take care of them on that meeting.
Got it.
Yes. Sorry about that.
I think this meeting
So
went
we're-
very well.
I missed it. That's the agenda for today. I don't know what I did with it.
Sarah, you, very good meeting.
Well, thank you. All of you, very good
I think
meeting.
it's getting past my bedtime.
I.
Alright, so.
Jay, yeah, it's, where's,
George's memorandum to the attorney. Which was read on that.
Around, come on.
Whatever. So, we agreed on some changes last time and I simply made them. Just reflect those changes.
What's crossed out?
So, okay, yeah, this is, doesn't show the change. The,
It shows the changes, it's just they like put them out in color. What's underlined will be added, what's crossed out will be crossed out.
Right.
oh, wait a minute, I'm sorry, I'm looking at the wrong damn thing. Yeah, that's right.
Yeah, that's what we talked about.
Yeah, no, the changes are, the deletions are crossed out as Hans mentioned, and the new language, any new language is underlined. So in the first line, Pete had, requested, the addition of, the words land use. And, we had discussed, eliminating the, middle part of the, second paragraph. And the addition of that line right at immediately thereafter. And that was pretty much it.
And we'll more, can we accept the draft as amended?
I'll second it.
What was that, Craig, was sorry?
I make a motion to accept the draft
Okay.
to Philip Saucier as amended about the no-mow zone.
Okay.
we have a motion and a second. Do you have any further discussion about the draft that's gonna be sent? Okay, so we're voting, Mr. Sakara,
Yes.
Mr. Seal,
Yes.
Mrs. Sergio,
Yeah,
Mr. Alexander, and me, Sarah Langes, 5 yeses, none opposed, motion carries. So,
So, probably it's easiest if I just, accept those changes, because this is the track changes on Word, and then send it to Hans to send to Lorna.
Well,
Send it to Lorna directly. Is that okay with you?
yep, that's,
Because it is in your name. Okay, that's what I'll do.
I can copy it.
And I'll copy everybody.
yep. Excellent. So that's done. So, next item in the agenda is,
Got a handout about the energy storage. This is something probably we need to consider updating some ordinance, because these batteries, energy storage facilities are, they use solar fields, they're buying up land, they're putting in these energy storage batteries. And that's good. They're using all sorts of different batteries. I mean, you can imagine a field full of big lithium ion batteries that catches fire, lightning strike or something.
yep,
And you got a fire you can't put out.
So these are without solar panels, so this doesn't include it in a solar,
Excuse me?
this is without solar panels?
Yeah, this is just energy storage, so, like on a major road like Highway 27, where they have bigger power lines or along existing power corridors. They'll put these storage facilities to take extra energy that's not being used, store it from when there's no power, and then use it. Minimize.
Do you have any sense of what kind of acreage we're talking about?
Maine's on plan to do 400 megawatts before 2030. So how they're gonna distribute these plants, we don't know, but they're looking at outside major cities, like Augusta has an expensive real estate. We're close to Augusta, would be a great place to put it.
Would, there's examples of 1, 2, 3, 4, 5, 6, ones that have already been constructed, have you seen any photos of them or anything like that?
Just online, I mean, they got sodium batteries. I mean, I'm learning too much about this. I don't want to say no.
Well, I'm just wondering. I mean, the ordinance that would need to be amended would be the commercial development review ordinance, of course, and we'd have to add a section probably to it, like we do for solar facilities, at the, I'm just thinking ahead of how do we even get started.
Well, I was gonna ask, do you think, what's the state, is this, does the DEP or any, do they have guidelines for?
It's been mandated by Governor Mills that we're gonna do this by 2030.
Right.
Next governor might change that, but
Yeah.
we need to have this on the radar.
Yeah.
But it's better to be in front of the situation than behind it.
I certainly agree with that. If that's, something that we need to anticipate, it's real. The other obvious question is, are there any model ordinances or standards out there that we could rely on? Because I don't know squat about these myself. I don't know what the electromagnetic, radiation is from these things, just like the large transformers at solar plants, that kind of stuff. I mean, there are a lot of fire.
Well, and this, thinking easy out would be just the fire protection. If Belgrade doesn't have that fire protection, to put out an acre full of lithium batteries, we can't handle them. But, that's a very cursory hours.
He's already overstepping the whole road. Living on these matter. To her,
Yeah, I've been,
but
the
doesn't
whole,
matter to her.
the whole last 4 years, I've been like that.
Well, the developer has to pass the permitting process, so.
Looks like this was part of a bipartisan piece of legislation.
It's not good.
Oh, you're excited about,
Oh, I was just reading the
Yeah.
introductory paragraph under main energy storage goals.
well,
Well, there are other states, like Massachusetts that apparently are going this route, as well, or at least pursuing it. Maybe, I don't know, if aggressive is the right term, but Massachusetts is usually pretty good about, unlike Maine, you know, when they establish a goal, they'll look at the consequences and try to plan for it. They did that with solar. And came up with standards for towns to look at as possible ways of regulating at the local level as well as at the state level. Maine never did that. Maine used to do that kind of stuff, but doesn't do it anymore.
It's Massachusetts Republicans,
Mhm.
it's, no, the Democrats. Oh, interesting.
I got a nephew in the business of solar farms up here, you know. And they down in Massachusetts, they call Maine the Wild Wild West.
Well, you know, I get this is just a story, but I get the, sort of support that, agendas for the Maine Board of Environmental Protection, and that's where, when DEP takes enforcement actions, that's where those issues are discussed. Usually their consent agreements are basically, it's not like going to court, but it's an agreement, so you don't have to go to court. And the penalty that has to be paid, what kind of actions need to be, and a lot of these solar farms, just one major soil erosion control problem after another.
That's what I
imagine.
So, you know, they just kind of go in ripping and tearing apparently,
Yeah.
which is pretty disappointing, really, this day and age.
I hadn't heard that.
Yeah.
They-
Well, and a lot of them,
They
they're
run
big
it on
corporations
land
from
down
out of state, they don't care,
Right.
you know, they don't care.
Mm-hmm.
Alright.
How about the big buck? Money.
So, okay, so,
Hold up.
So,
Order down there.
are we on a timeline with this, or,
Not really, but
so we're adding this to the list? Okay. Thank you. This is getting to be bigger than my Christmas list.
I think the shoreline zone list got bigger tonight too with that. So what we put into the 16C1. Chapter 1000 is very limited, it's one sentence, and we got 5 or 6 in there. So might be we do that.
I didn't have it. What I think of that? No. Maybe I did it. Get over here. It was section CE, isn't it? The one that we, that is,
16C, I believe it was 1 or 3. I'll tell you in a second. 1. Chapter 1000 says every applicant for a permit shall submit a written application including a 2-scale plan on a form provided by the municipality to the appropriate official as indicated in section 14. Stop. That's it. Our ordinance goes on. Site plan shall include at a minimum the location of existing and proposed structures, roads, driveways, walkways, wastewater disposal systems, drinking water wells, and lines, power lines, right of way, stormwater runoff, wastewater disposal system, drinking water wells and lines. Oops, sorry, I went through that one. Property lines, drainage ways, intermittent streams, vegetated areas, and the normal control measures, high water marking lake. Pond, stream, or wetland, application for additional or alterations of existing structure shall include a two-scale drawing indicating drawing show side views of the existing and proposed structure. The application shall also include a lot area of shoreline zone. So I'm surprised you didn't ask that we deny the application based on it didn't show drainage ways. I mean, that's all written in the same way, drainage way. When have you ever seen one of those on an application? Intermittent streams. Nobody includes that. We put a lot of fluff in there that needs to be taken out.
Well, the flip side of that is, I don't know of many sites we've seen that had an intermittent stream going right through it.
That's right. That's what I'm saying.
But drainage ways. I mean, that's kind of what your solar fields are supposed to have to mitigate the erosion problems they're all having. You know, George said they go and they clear an area and they put in these cement footings, put poles on them, let grass grow, but there's no other root structure. All the land starts to wash away.
Yeah, they don't have any of those settling pools there. Like in Minnesota, they do in the shoreline zone in a big way.
They have what?
Settling pools in between the lots, you know, they have.
Retention ponds.
Yeah, yeah, they do that in a big way, and I'm getting information together on that from Minnesota. Because I want to make that presentation to this group, comes in and to what, yeah, the no mow your lawns or whatever, you know. There's a different way to approach.
DEP's experience with settling ponds is that people don't maintain them. You have to clean the silt out of them. They look great the first year or two, but if they're really active and they're receiving a lot of storm water, they get all gunked up and they have to be able to infiltrate. If you get a lot of silt in them, like off of a parking lot, then the infiltration rate goes way down and they don't function properly, and you get too much of it going over the top. So you got to think long term, not just short term.
Well, Minnesota's been doing it, and they've played up the lakes.
Yeah, well, Maine and New Hampshire have been doing it for a long time too. Not in that context, but with commercial development.
Oh, yeah. Anyways,
It might be different where you don't have parking lots and driveways and roads.
All right, so, next will be the minutes. All right. So we have the minutes here from November 20th.
Is that it says the sixth on the agenda, but that. We've already done the sixth, I think.
Matt, do you want us to hold on
Oh,
to
yeah,
all the stiff stuff, or you're gonna print more stuff out, or we'll hold on to it all?
no, it was hold on.
I'm not gonna print anything again.
I make a special bag. I have a different bag because of this, so I don't have to mess around with it. Let's see. So we're doing the minutes of the 20th, the agenda says the 6th, but it's supposed to be the 20th.
You're right. The bad secretary.
We'll let you out of the hook. We tender with you.
what are you looking at now?
So we're looking at the minutes for corrections. Agree with this first.
No, that's okay, those are part of the effects growth.
Okay.
They're also,
I'll
I
put it-
already have the duplicates in.
Well,
It's for recycling.
Yeah.
Thanks.
We'll see.
They're rock roll.
Ready?
All right, so, any changes to the minutes?
I have some.
Ah,
On the last page, the tree regulations discussion. We weren't really talking about tree regulations. Yeah, I did say something about the. Trump was, we were talking about no mow zones and I was just bringing up an example of some of the few things. And one of the things I threw out there was. They don't even recommend trees around trout ponds because it ruins the ponds. But we were actually talking about no mow zone. I think that whole thing was to be struck out over there unless it was different.
Yeah, we didn't talk about tree regulation.
Yeah, we had no tree regulation discussion at all.
Oh.
Yeah, that's true. Right.
Violation, we put them down.
Do you want that whole thing, tree regulation discussion in the paragraph, all in one?
all gone,
Yeah.
all that is gone.
I have one item, a couple items, Penny, under, the first discussion item on page 1, board agreed that times are changing, they debated commercial, this had to do with the internally lit signs. They debated commercial sign regulations with George noting that internally lit signs are currently limited. What I think might be clearer is rather than eliminate limited to and substitute only regulated in. So that it reads with George noting that internally lit signs are currently only regulated in certain commercial developments under the commercial development review ordinance.
So it's gonna say, George noting that internally lit signs are currently only regulated in commercial developments.
Yes.
Okay, got it.
And then on the last page, the paragraph under state mandate postponed to January. After the comma on the first line, town discussed a compliance issue with an unfunded state mandate. After the comma, I would insert the latest state housing law, comma, deciding to table the matter to January rather than addressing it at the June meeting. Is that what we really said? June meeting, or was it?
January,
Oh, at the June meeting?
Well, it says table to the matter to the January meeting after, rather than addressing it at the June meeting.
Maybe swap June.
I think, yeah, I think June and where it says January should read June,
oh,
Okay,
and where it says June, it should say January.
good pick up. Okay, so it says, after the comma, it says the latest state housing law.
Deciding to table the matter to the June meeting rather than addressing it at the January meeting.
That's the compliance issue with an unfunded state mandate. The latest state housing law. Deciding to table the matter to the June meeting.
Yes.
Okay, all right.
now the title, you have to change it too.
I'm
It
sorry.
says, the title says state mandate postponed to June,
Okay, change it from January to June.
that's right.
Yeah.
Oh, right.
Huh?
That's your purpose.
Let's see. No.
So any more changes? I see none. I hear none. So I will entertain motion to approve minutes.
I'll make a motion to approve the minutes of November 20th, 2025, as amended.
Second.
So we have a motion and a second. Any further discussion? We're gonna vote. Mrs. Carroll,
Yes.
Mr. Surgeon,
Yes.
Mr. Seal,
Yes.
Mr. Alexander, and Ms. Sarang is 5 in favor, no opposed, minutes are approved. And so I will entertain motion to adjourn. Oh, we have discussions, hands, CEO notes, okay, so I will entertain motion to adjourn.
Make a motion to adjourn.
A second.
So we have motion and a second in discussion, I hear none, Takara,
Yes.
Sergeant,
Yeah.
Seal,
Yes.
Alexander. And Ms. Sarang is 5 in favor, no opposed, and meeting